Good afternoon. My name is Katie Kohn, and I am the supervising attorney of the Domestic Violence Unit at Legal Aid Service of Collier County. I'm here this afternoon to talk about domestic violence and domestic abuse in family law cases in Florida. The how, when, and to what extent is domestic violence and domestic abuse considered in cases of divorce, paternity, and child support. So again, just briefly what I'm gonna go over today is the types of domestic abuse that may be relevant in a divorce, paternity, or a child support case, the impact of the domestic abuse on decisions that a judge may make regarding parenting issues, equitable distribution, and alimony, and also when and how to raise those issues in a family law case. So first, to cover what issues is domestic abuse considered in a family law case. The place where it's going to be most relevant, most important, and most considered by a judge is in regards to children's issues. So decisions regarding decision making and a time sharing schedule. And those sorts of decisions are made in a divorce case where there are children involved and a paternity case. I'm going to touch briefly on child support cases brought by the Department of Revenue and how, if there are issues of domestic abuse that may be raised in regards to children's issues. I'm also going to discuss today if and how issues of domestic abuse could be considered when a judge makes a decision about equitable distribution, which is the dividing up of assets and debts in a divorce case. In a paternity case, there are no decisions regarding equitable distribution. And I'm also going to discuss if and to what extent domestic abuse is considered or is relevant in a decision regarding alimony, which again would be only addressed in a divorce case, not a paternity or child support case. So first, the types of domestic abuse that may be relevant in one of these cases. There are many different forms of domestic violence, intimate partner violence, domestic abuse. There's physical, sexual, emotional, psychological, and financial. And as we're going to discuss in more detail, judges can consider all those different forms of domestic abuse depending on what kind of decision they're making and depending on what the statute allows them to consider. There are some specific statutes specifically regarding issues involving children that specifically mention domestic violence. And in Florida, domestic violence refers to physical violence in the statute. So when domestic violence is discussed specifically in the statute, it is generally referring to the laws that are on the books in Florida regarding physical abuse, assault, battery, aggravated battery, sexual assault, sexual battery, things of that nature. But again, in a family law case, as we're going to discuss, there are opportunities and ways to bring up other forms that are non-physical of abuse that are relevant to the judge's decision. So first, I'm going to discuss how domestic abuse is considered in children's issues. When a judge makes a decision in regards to children, and this is regarding decision making and a time sharing schedule, the judge is going to do his or her very best to determine what is in the children's best interest. The court is required to determine those things with looking to the best interest of the child. And again, that's in regard to parental responsibility or decision making, how you and the other parents are going to make decisions for the children after there's been a divorce or a final separation in a paternity case, and the time sharing schedule, which is when are the children going to be with their mother, when are they going to be with their father. So in regards to the parental responsibility, this is one of those statutes that specifically refers to domestic violence and specifically requires the court to consider domestic violence if it is present. I'm going to go through the statute. I know there are a lot of words up here on the screen, but I'm going to try to go through and explain it. So when the judge makes a decision about parental responsibility, initially the statute says that the court should order or shall order that parental responsibility be shared between both parents, meaning that both parents are involved equally in decision making, unless the judge finds that shared parental responsibility, that joint decision making, would be detrimental to the child, would be harmful to the child. And it specifically says in the statute that evidence that there has been a conviction of a misdemeanor or higher involving domestic violence creates a rebuttable presumption of detriment to the child. So if the other parent has been convicted of domestic violence, battery, aggravated battery, a charge involving domestic violence that is a misdemeanor or higher, the judge is going to initially will presume or assume that that means it is harmful to the child for that parent with the conviction to make decisions for the child. The other parent has the opportunity to do what's called rebut that presumption, to convince the judge that he shouldn't make that assumption, that it wouldn't be harmful for the convicted parent, the abusive parent, to be involved in decision making. But if that parent, if the convicted parent is unable to convince the judge of that, then the judge cannot order shared parental responsibility. And the judge also must take that into consideration when developing a time sharing schedule as between the parents. The last bit of this statute that I want to point out is that final bullet point that says whether or not there's been a conviction of domestic violence. If there is domestic violence present, the court must consider evidence of domestic violence or child abuse as evidence of detriment to the child. So Florida law here specifically recognizes the impact that domestic abuse and domestic violence specifically can have on two parents who need to make decisions for children. And if there is a history of domestic violence in your case where the other parent has been convicted either after a jury trial or has entered a plea where they have been adjudicated guilty for domestic violence, then this statute would apply, and you would want to bring up that evidence to the judge to demonstrate that they have this conviction for domestic violence battery, and that you should be the parent to be making the decisions, and that it would be harmful for that other parent to be involved in the decision making. And again, I want to just reiterate back to the decision making. Even if there hasn't been a conviction of domestic violence, but there has been a history of domestic violence that has not been reported or has not led to a conviction or an injunction for protection or anything kind of final like that in the court system, it does not mean that it is not relevant or that it shouldn't be raised to the judge. And it's specifically required that the judge consider that abuse if it has happened in the past. Now, in regards to what the judge considers in creating a time sharing schedule for the children and the parents, this is a statute that, again, requires that the judge determine what's in the best interest of the child or children by evaluating all of the factors that affect the welfare of the child and that consider the circumstances of the family. In this statute, there are 20 different factors that are specifically enumerated. Actually, there are 19 factors specifically enumerated, and then one factor that allows the judge to consider anything else that may not be specifically listed. But there are some of those factors that I'm going to go through that I think provide an opportunity to raise the issue of domestic abuse and domestic violence, to indicate to the judge that that has occurred, how it has affected the child, and how the judge should take that when they're determining a time sharing plan. There's one factor in particular, factor M in this statute, that requires the court to consider evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect. And again, that's regardless of whether there's been a court case about that, whether anyone has ever been arrested, whether the domestic abuse has ever been reported. And again, I'll just mention for this factor, it does specifically reference domestic violence, which again does refer to the physical violence I talked about at the beginning, is how it's defined in Florida law. So this particular factor does more refer to the physical violence more than emotional or psychological abuse. But I'm going to talk in just a few minutes about how those other forms of abuse are referenced in other factors in the statute. But I wanted to point out that this particular factor specifically requires the court, if there is evidence of domestic violence, that they have to consider it when they're making their decision, and they have to put in writing that such evidence was considered when they evaluated the best interests of the child. So there's these other factors that I'm going to go through individually that I think provide opportunities and where you would want to introduce evidence of domestic abuse, domestic violence, but particularly those other forms of domestic abuse that are non-physical, the emotional, psychological abuse that so often happens, but often doesn't get reported or recognized based on how domestic violence is defined here in Florida. So factor A is regarding the demonstrated capacity and disposition of each parent to act and encourage a close and continuing parent-child relationship. Parent-child relationship, to honor the time-sharing schedule, and to be reasonable when changes are required. Factor C is the demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child, as opposed to the needs or desires of the parent. Factor F is the moral fitness of the parents. Factor G is the mental and physical health of the parents. H is the home, school, and community record of the child. L is the demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child. And there's just three more. Evidence that either parent has knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. This factor is really just stating if somebody lies about being involved in a domestic violence case or a case where charges were brought for child abuse, that needs to be considered by the court. Sometimes that can happen if somebody has a case in another jurisdiction, not here in Collier County. If your family law case is pending here in Collier County, but there was an arrest over in Miami-Dade County a few years ago, and the abusive parent assumes that the judge doesn't know about that, has no way of knowing about it, and assumes that you don't have proof that there was a prior case, and they lie and say they've never been abusive to you. If you have evidence of that prior case, that would be relevant for the court to see that the abusive spouse has provided false information regarding a prior or pending action. Paragraph Q, the factor Q, the demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. I included this one because oftentimes where there are issues of domestic abuse, there are also issues of substance abuse. So I do believe that that provides an opportunity to introduce not only issues of substance abuse if the abusive spouse has that, but what happens as a result of the substance abuse if the abusive spouse gets aggressive, gets violent, gets loud and angry, especially if the child is around. And the last one is that catch-all. I stated that factor T, any other factor that is relevant to the determination of a specific parenting plan, including the time sharing schedule. So I think that all of these factors refer to an ability or a willingness of parents to cooperate with each other, to respect each other, to work together for the good of the children, to set a good example, and to co-parent with each other. Where there has been a history of domestic abuse, where the abusive parent has constantly been insulting, belittling, humiliating to the other parent, intimidating them, threatening them to take away the children or not allow them to see the children, threatening to report a parent for their immigration status, controlling one parent, where they go, how they can see or communicate with the children. That form of domestic abuse is going to be relevant in each of these factors, I believe, because it is showing that the abusive spouse often is unable to co-parent, to respect the other parent, to put the child's needs above their own desire to control the other parent. And that will be necessary to show the judge how that abuse has happened, how it has impacted the child, how it has impacted the ability for both parents to be involved in raising the child. Now, I mentioned I was going to talk about child support cases a little bit, and this is specifically in regards to an administrative action brought by the Department of Revenue seeking child support. In the statute, the Department of Revenue, when they file one of these cases, is required to provide you with what they call a parenting time plan. It is a very abbreviated plan that provides for a time sharing schedule, a regular schedule, and a few holiday time sharing. That's a standard plan, or you could enter into your own. But the only way that that parenting plan can be entered in a Department of Revenue case is if both parents are in agreement to the proposed plan and they sign it and it's entered into the case. So if there's a history of domestic violence in your relationship or domestic abuse, and you are not in agreement to entering into the proposed plan, you do not have to sign it, and that is the end of it, and no parenting plan or time sharing plan will be entered in that child support case. The standard parenting time plan that the Department of Revenue proposes is that one parent have every other weekend from Friday until Sunday, and then one evening during the week, and then the other parent has the remaining time. It also provides for alternating time over Thanksgiving break, and splits the time for winter break, allows for 2 weeks of time sharing during the summer for the parent that does not have majority time sharing. So if there's been a history of domestic violence and you feel that the parenting time plan that you receive from the Department of Revenue is not appropriate for your family, you simply do not have to sign it, say you don't agree with it, and that's the end of it. The department can't force you into signing an agreement. If you simply don't want to enter it into it, the case for child support will go forward without any sort of parenting time plan or time sharing plan attached to the child support award. So now I want to shift and talk a little bit about how domestic abuse is considered in a judge's decision regarding equitable distribution. And again, now we're shifting and just talking about divorce cases, because those are the only kinds of cases where equitable distribution and alimony are addressed. So is domestic abuse considered in equitable distribution? And before I answer that, I'll just say equitable distribution means the part of the case where the judge divides up the assets and the debts that the spouses have gotten during the marriage. So does the judge consider domestic abuse when it is deciding how that division happens? The short answer is no. The slightly longer answer is they don't often consider it, and even if they consider it, it wouldn't be directly considered. So talk about that a little further. The statute regarding equitable distribution starts off with a presumption that the division should be equal, okay? It is a relatively difficult presumption to rebut that it should be unequal. And the judge is going to assume from the start that it should be equally divided, the assets equally divided, and the debts equally divided. And they don't need to consider much else when they are going to determine how to divide the assets and the debts. Now, if you're asking for an unequal distribution of the assets and the debts, meaning you want to get more of the assets or you want to have less of the debts, the judge can do that. However, you have to demonstrate that that would be more fair than an equal division. And there are factors listed in Florida Statute 61.075 that lay out what the judge considers if they're going to do an unequal distribution. None of those factors, specifically factors A through J, none of them touch on domestic abuse or really anything outside of finances. This statute is focused on the financial aspect of a divorce and how that's going to happen, not so much emotional, psychological things that have gone on in the marriage. But if you are asking for an unequal distribution, there are a few factors, really just two, that I think you could introduce a history of domestic abuse and make it relevant for the judge's decision-making in equitable distribution. Though I will stress that it's rare that a judge will consider a history of domestic abuse when making these sorts of financial decisions. But in factor B is the economic circumstances of the parties. And J is any other factors necessary to do equity and justice between the parties. So the first factor B, I think, can be relevant if there's domestic abuse, because oftentimes if there's been an abusive spouse who has prevented the other spouse from working, who has interfered with the other spouse's career or jobs, by constantly showing up, by calling repeatedly, by checking in on the person, or simply by not allowing them to work, or if there's been situations where one of the spouses is working, but there's an abusive spouse who controls all the finances and does not allow the abused spouse to have access to any of the funds, to have any savings, any retirement savings, anything like that. That can go to what the economic circumstances of the parties are, and explaining how the abused spouse got into that situation of not having any work history, of not having any savings, may be relevant to the judge's decision to do an unequal distribution. And factor J, again, if you can connect any of the domestic abuse to your current financial situation, or to how going forward is going to be more difficult because of the abuse, that may be a way you can explain to the judge what the situation is. Now, again, is domestic abuse considered in a determination of alimony? And again, the short answer is not often, or at least not directly. Same as with what I stated for equitable distribution. And alimony, just briefly, is where one spouse pays the other spouse financial support after the divorce is ended. And again, the judge, in your case, will consider a list of different factors in determining if alimony is appropriate. And this is statute 61.08, and the factors are listed in subsection 2. So again, this statute is mostly focused on the financial situation of the parties, their ability to pay alimony, and the need for that alimony going forward. There is not anything specifically raised in this statute regarding domestic abuse or domestic violence. But again, I've listed some of the factors here that I'm going to go through where I think domestic abuse would be relevant for you to raise in regard to these factors. So factor C is the age and the physical and emotional condition of each party. Factor D, the financial resources of each party, including non-marital and marital assets and liabilities distributed to each in the equitable distribution. The earning capacities and education levels, the vocational skills, employability of the parties, and again, the catch-all, any other factor necessary to do equity and justice between the parties. Now for factors D and E that I just read, those again can be relevant. Domestic abuse can be relevant to those, like I discussed with equitable distribution. If there's been an abusive spouse who has prevented the other spouse from working, from having access to any of the funds, from being able to improve their financial situation or their career, this is where those things can come into the judge's consideration. Factor C, the age and the physical and emotional condition of the parties. If domestic abuse, domestic violence has led to physical injuries, emotional injuries that prevent the abused spouse from working, that will be relevant to that factor in the judge's consideration of alimony. So now that we've kind of gone over the different aspects of when a judge could consider domestic abuse, let's talk a little bit about when do you tell the judge about that and how do you do that? So first, the first place I would recommend raising issues of domestic abuse is just right off the bat initially in the pleadings. And this is especially true in regards to children's issues. When you file for divorce or paternity, there's questions you need to answer in your petition about what kind of time sharing you're requesting for the other party. So if you are asking that the other party have limited time sharing or supervised time sharing or no time sharing, you need to explain in the petition what is the basis for that. Why do you think that time sharing for the other spouse is, or the other parent is, in the children's best interest? So that may be where you want to initially raise these issues of domestic abuse, to put the judge on notice that these are going to be issues in your case, and to put the other side, your spouse, on notice that you are going to be raising these issues. There's other documents you file initially with the petition or your counter petition. Notice of related cases. That's where you can list any other cases that you've had with your spouse, including criminal battery cases if he or she has been arrested for domestic violence, injunction for protection cases. Those you can put on, you'll want to put on the notice of related cases, again, to indicate to the judge that this has been a history in your case that is going to be relevant going forward in the case. And also the UCC JEA, which is a form that you complete when you have minor children in a divorce or a paternity case, where you list where the children have lived for the past 5 years. But it also asks questions on that form if you've ever been involved in any cases regarding time sharing with the children. If you have had an injunction for protection case with your spouse, those cases will generally involve time sharing with the children. Even if it's a temporary schedule, there will be issues in there regarding time sharing. So you'll want to list that case on that form. You also want to raise these issues in motions for temporary relief and at hearings on those motions. So a motion for temporary relief, where this would be relevant, would most likely be in a motion for a temporary time sharing plan, where you're asking the court to set up a schedule during the divorce when the children will be with mom and when they'll be with dad. And if you're, again, asking for limited time for the other parent, and one of the reasons is because of a history of domestic abuse, you may want to mention that in the motion, and certainly will need to present evidence of that at the hearing on the motion to justify your requests for limited time or whatever time you are asking for the abusive spouse. If you're also able to file motions for temporary relief for financial relief. So if you're asking for temporary alimony, and one of the reasons you've been unable to find work or you're unable to fully work has been a result of domestic violence, physical injuries, emotional abuse, or anything else, you can put that in your motion for temporary relief. And then again, you'll want to present evidence of that at the hearing on the motion. And then certainly at your final hearing in any of these cases, where the judge is determining a final schedule for the children, making decisions, final decisions in regards to equitable distribution and alimony, you'll need to present all the evidence you have at that time to convince the judge to enter an order awarding you the relief that you're seeking. Again, in regards to the time sharing schedule, the parental responsibility, the equitable distribution, or alimony. Now, how do you introduce this evidence, or what kind of evidence do you want to present? First and foremost is going to be testimony, and your own testimony is evidence of what has happened in the past. And a lot of times that may be all you have. That may be the only evidence that you have of domestic abuse or domestic violence because you never reported it in the past. But like we discussed, there's several factors, especially in regards to the children's issues, that say even if this has never been reported, even if there's never been a court case, this is still relevant and it still needs to be considered if evidence of domestic abuse is presented. So there can also be testimony of other people that have firsthand knowledge of the domestic violence or domestic abuse. So this can be neighbors, family members, friends. It can be police officers that have responded to your home after a domestic violence incident. It can be teachers of your children who have made disclosures or who have witnessed altercations in the parking lot. It can be anyone, again, that has firsthand knowledge, that has witnessed any forms of abuse that you want to have them come in and tell the judge what they've witnessed. You can introduce photographs of your injuries, recordings of things that have occurred, and when you bring these things to court, you'll need to have them in a way that you can provide them to the court, the way you can show them to the court or have the court listen to it. If it's a voicemail recording of threats from the abusive spouse, you have to come with a way to be able to show the judge those things at the time of the hearing. And you can also present documents from other court cases. So things that would be relevant and able to be admitted as evidence would be a judgment and sentence from a criminal case. If your spouse has a conviction for battery against you, you're going to want to have that judgment and sentence to show the judge. If the criminal case was from a jurisdiction not Collier County, you're going to need to have a certified copy of that judgment that you get from the clerk of whatever county the judgment is from. You can also get an information from a criminal case, which is a formal charging document which states what the abusive spouse was charged with. Also, injunctions for protection. It can be a temporary injunction, or if you have a final injunction, even if it's no longer in effect. Even if it is already expired, it will still, and it is still relevant to show the judge the history of domestic violence. And also other filings or judgments from other cases. Oftentimes, one aspect of abuse could be filing other lawsuits against you to, try to frighten you or obtain things from you. It can be evidence of a pattern of conduct that can show the judge, how the abusive spouse works and how they may be trying to control or take advantage of you. Something that is not going to be considered evidence is a booking sheet. So the police report that an officer generates after he or she responds to a domestic violence incident. You can't bring a booking sheet to court to show the judge. They're not going to be able to look at it because it's considered hearsay. You can have the actual officer that wrote the report come into court and testify as to what happened, but you can't just bring that booking sheet to show the judge. And the most important part of introducing this evidence to the judge is connecting it to one of those statutory factors that we talked about, connecting it to what you're asking the judge to do and connecting it to the law that allows him to do that. So you really need to make sure that you know why you're talking about the domestic abuse. And that's why it's important to know what those factors are so that you know what the judge is considering and what information he or she needs to make a decision. And I would say this is especially important in regards to those financial decisions the judge makes that I talked about, because generally speaking, domestic abuse and domestic violence is not going to be considered in those types of decisions. But if you can specifically connect the evidence of domestic abuse to one of those factors to explain to the judge why it is relevant, why he or she is allowed to consider domestic violence, because it has resulted in your inability to work or your inability to work full time. So connecting it to one of those statutes is a very important thing to do. Now, I'm just going to go over a couple of statistics kind of at the end here to wrap up, to illustrate why I believe it's so important that we talk about this topic, because unfortunately, domestic violence is so prevalent in our state, in our county, that there are so many people, unfortunately, that do experience domestic violence and domestic abuse in their home, and that the Florida statutes do recognize the impact that that can have on the victim of abuse, on children that witness the abuse, and that they do specifically consider those things in making decisions of family law cases. So in 2019, which is the most recent statistics I was able to find, there were, in Collier County, there were over 1,600 reported domestic violence offenses just in Collier County. In 2019, in the whole state of Florida, there was over 105,000 reported domestic violence offenses. And according to the Bureau of Justice Statistics, about 50% of domestic violence offenses go unreported. So these numbers are not at all representative of how much domestic violence occurs. And again, this is domestic violence statistics, not domestic abuse. And so much of the domestic abuse that occurs is unreported. So I just want to, I raise this in the hopes that people understand, unfortunately, again, how prevalent this is in households, and that it is important to raise these issues in these family law cases if there's a concern that the abusive spouse isn't going to be the best parent for the child to be around because of the abuse, because of the way they interact with the other parent. And if you are a victim of domestic violence, of domestic abuse, there are many great resources in our community that can help you get out of that situation, or at least talk to somebody about what your options are. Like I said, here at Legal Aid, we have a unit solely dedicated to victims of domestic abuse. We assist with injunctions for protection, divorce cases, paternity, and other family law matters. But we also have units here that help people with housing issues, tax, immigration, and consumer law issues. So I encourage you, if you're needing assistance, please give us a call and see if we can help you. There's also the Shelter for Abused Women and Children, Project Help, and the Florida Domestic Violence Hotline. There's also the Collier County Bar Lawyer Referral Service. If you are looking for an attorney to help, they can provide you with information that will connect you with attorneys in the community, and those attorneys will give a consultation to you for a fee of $50. But again, if you are a victim of abuse, I encourage you to reach out to Legal Aid to see if we can help you in any way, even if it's just to answer some questions, provide you with some more information as to what the options are going forward. So I want to thank you very much for your time and attention. My email address is up on the screen. If anybody has any questions in regard to this presentation, I'd be happy to answer them. If you want to send me an email, please do. And I wish everybody a very happy holiday season, and I appreciate your time and attention today. Thank you so much.